All right. Hello, everyone. We are live once again. It is Bradley Chaplick. I am a condominium lawyer at Horlick, Levitt, Lella. Joining you again this Wednesday at noon for HLD's Ask Us Anything, our live stream where you ask us questions and we give the best answers we can. And we're doing this again every Wednesday at noon to reach out to our friends and clients in the condominium industry and to stay in touch. So, once I said, I'm Brad Chaplick. I know some of you might have been expecting to see Mr. Horlick. He was going to cover for me because I wasn't sure if I would be able to do it today, but I'm here and I'm able to do it. So I'm going to take my week and then it'll be Brian next week. If you're not already a subscriber to our channel, I'd ask you to consider subscribing. You can hit the button below, and by subscribing and hitting the bell notification, you'll be notified of future videos that we put out. We do our live stream and we also do case law updates. So there's lots for you to view and get the latest legal updates on our YouTube channel, which is great. So I'm going to be checking my notes here because there's a lot going on right now. But first thing I will do, because I don't see any questions coming in yet on the chat. If you have questions, please type them into the chat, like right here. I'll just type something in. Oh, there's Julia saying hello, so I'll just type in questions here. There you go. If you can hear me better than you could before, it's because we've got new microphones. So that's a nice little development. We're always tweaking the tools that we use to make these videos, so hopefully they're getting better over time. That's the idea. But first I want to go to the mailbag. So we had a question come in from a condominium manager asking if we could review the different ways to hold a AGM during stage 3. So there's a few things to talk about here, and really what the question is getting to is whether you could have your AGM not using an electronic meeting and not doing it with an in-person meeting, but just like a paper meeting by proxy. And for the reasons I'll explain, I don't think you can, but you have a lot of options. So we're in stage 3. Looks like we're going to be in stage 3 for a while based upon some sort of negative trends in the COVID numbers in Ontario. And what does that mean for holding a meeting? Well, it means if you're indoors, you're limited to 50 people, and those people have to be spaced apart by 2 meters. And they also have to be wearing masks. So that makes holding a meeting difficult, but not impossible. If you have a small condominium corporation, you might be able to hold an in-person meeting with masks on. But for most condominium corporations, limiting yourself to 50 people is going to be a problem because it means that some people who are unit owners and who would otherwise be entitled to attend the meeting won't be able to attend. Or they'll have to watch a live stream of it or something virtually. But all of this is problematic for holding in-person meetings. So while it is, of course, legal to hold an in-person meeting, provided that you meet the requirements for social gatherings, you are going to find that you have practical problems, including the fact that everyone's wearing a mask and might be hard to understand each other. So in-person meetings are possible but difficult, limited to 50 people. Okay, what else could you do? Excuse me. Well, you could have a electronic meeting, right? And up until November 21st, you don't need an electronic meetings bylaw. You're exempt from that, what would ordinarily be a requirement to pass a special bylaw, and all condominium corporations can hold meetings of owners electronically. So what is an electronic meeting? It's basically a meeting done using Zoom or some sort of similar webinar software where the board members appear as panelists on the screen, and the property manager and your chairperson and your meeting host, all these people are panelists, and all the owners are essentially attendees of the webinar, and they can participate and raise their hand and do all sorts of things to speak. But the format, it's not exactly like a typical Zoom meeting. It's a little bit different, but it works really well. And you combine that with some electronic voting software, and you have an electronic meeting of owners. And that's what most condominium corporations are doing. I would say nearly all. And you can do that without a bylaw until November 21st. Or can you? Well, yesterday we get a email from the Ministry of Consumer Services, and they are updating us on this November 21st deadline. So for everyone who's saying, like, what are you talking about, November 21st? I'll explain. There was a temporary amendment to the Condominium Act, which had a transition provision of 120 days. That temporary amendment was tied to the state of emergency being declared in Ontario. The state of emergency was ended on July 24th. 120 days after that is November 21st. That's how we get this November 21 deadline. Okay, great. So the November 21 deadline is for the transition of all the electronic service of notice and electronic meetings and electronic board meetings. Great. There's also a deadline for condos to hold their AGMs, and that depends on when your fiscal year end is. For a lot of condos, that deadline is 90 days after July 24th, which is October 22nd. For some condos, it's going to be October 31st. For others, it's going to be November 21st. For some, it's going to be November 30th, December 31st, so on. So there's a range of deadlines for your AGM. The ministry confirmed that the deadline to hold your 2020 AGM will not be extended. It's not going to happen. So if you're hoping to get more time to hold your AGM, no, they said it's not going to happen at all. But the ministry is considering or working on an extension for the ability to hold a virtual meeting. So that's great. So that gives you more time to pass your bylaws and get organized and hold your virtual meetings. And we don't know if that extension will actually come to fruition or how long it's going to be. So, the advice to condos stays the same. You should pass your bylaws, hold your meetings electronically. So we'll talk more about that later. But centering back on the question, which is, how can we hold our meetings? So we've talked about in-person meetings, legal, but you're going to have practical problems. Electronic meetings, recommended, best option. The idea of a combined in-person virtual meeting, it's technically possible, but again, you're going to have practical issues, the same as holding an in-person meeting. You're going to run into all kinds of technical problems with that, and so it's difficult, and we would sort of suggest that if you're going to do it electronic, you should make it all electronic for now. You'll find it's a lot easier. It's having to do a combined meeting is essentially twice the work because you have to make provisions for electronic and in person. So it's a big job. And then the last option that people have been asking about is, could you do a meeting by proxy? So there are certain circumstances where you could have a meeting of owners by proxy, but an AGM, in my view, is not one of them. So when could you have a meeting of owners by proxy? Well, let's say you had like a single issue meeting. So you were just trying to pass a bylaw, even perhaps an electronic meetings bylaw. That you might do by a proxy paper meeting, but you shouldn't do your AGM by paper meeting. Why? Because there are things that owners have the right to do at the AGM, like other business and ask questions of the auditor, that would be missed if you had a paper meeting. And so because of the owner's right to participate, and not just the right to have an AGM, but rather the right to participate in the AGM, in my view, holding your AGM on paper really doesn't meet the basic minimum requirements of the Act and should be avoided. So you would be better off holding your meeting late than you would holding it by paper if you had to choose. Like, if you couldn't hold it electronically now for some reason and you had to choose, do we do a paper meeting now to get within the timeline, or do we hold the meeting late and do it properly? I would say you're better off holding it late and doing it properly than doing it now, but in my view, incorrectly. So better late than poorly would be my advice to condos. So looking at some of the questions that have come in, let's see if we can get to those, and then we'll talk about more of the really interesting announcements that have come in within the last few weeks. So Miriam, Homeowners are questioning using a lawyer to chair our AGM. What can we tell them? Is there anything in the Act that requires a lawyer to chair the AGM? Marion, your particular condo has used a lawyer to chair the AGM for many, many, many years. So I find it a little bit odd that owners would be questioning it, but it's a fair question. So let's talk about why you would have a lawyer chair your AGM this year. This is going to be your first time as a corporation holding a virtual meeting. It's new for everybody. And so I think just for that reason alone, you would want to have a professional chairperson. Doesn't necessarily mean it has to be a lawyer. It could be an experienced condominium manager, or it could be someone who is a professional chairperson working for a company that provides virtual meeting hosting. But you want to have a professional chairperson of some kind, just because the board might not have the experience to host and chair an AGM virtually. And maybe after you see the lawyer do it, and then the board could chair future meetings on its own. But the first time around, I think you're going to find that it would be difficult to do it on your own without a professional chairperson. And also, if you're passing any kind of bylaw, then you would want to have the lawyer attend the meeting anyways to answer questions on the bylaw. So if the lawyer is going to be attending the meeting, then you might as well put us to work and make us do something and let us chair the meeting, just as a productive use of the time that you're paying for anyways. So that's what I would suggest to owners. There's nothing that you're not required to. It's just a good practice, especially this year. In other years, maybe it's not necessary, but for your first virtual meeting, yeah, good idea to have a professional chairperson. And that's really the best answer. So yeah. Adib, when is it appropriate for lawyers to chair AGMs, and can property managers and regional directors do it? I just answered this question. So like I said, it's totally appropriate to have a condominium manager or a regional chair the AGM if the person is comfortable doing so and has the experience and knowledge to do it. I know lots of condo managers who are excellent at chairing meetings, and they do a great job, and they've done hundreds of them, and they're great. I also know other managers that don't have the experience and wouldn't feel comfortable chairing a meeting. There's a lot of technical legal issues that can come up during an AGM, and so you might want to have a lawyer do it a couple times, guide you through it, and then once you are familiar with things like rules of order and how to deal with a point of order and objections during the meeting and all that stuff, it can get a little tricky if you don't know that stuff. But if you know the rules of order and parliamentary procedure and you want to run a meeting, go for it. Great. Nothing says you have to be a lawyer. But lawyers know how to do it. It's our job. So we're happy to do it. Our board will be holding a virtual AGM before November 21st. We also want to pass a bylaw to increase the board from 3 to 5. How will this work as a bylaw to pass on a virtual AGM? Oh, that's a great question. How does bylaws work? Works the same as any other meeting. The virtual AGM would have voting by proxy, just like a regular meeting, and would also have electronic voting, so basically an electronic ballot, just like a regular meeting has a paper ballot. And so you pass the bylaw the exact same way. Owners vote yes or no. And there can be discussions and all these motions and all that kind of stuff. I would say if you're passing bylaws, that's a really good time to have a lawyer at your meeting, because lawyers can answer questions on the substance of the bylaws and also on procedural issues that come up, like if people want to make amendments to the bylaws. So anytime you're going to be amending your condo documents, it's a really good idea to have a lawyer present at the meeting. That's sort of like one of the criteria of when you would want to have a professional chairperson, and especially the lawyer who wrote the bylaw actually at the meeting to discuss it. But not mandatory, just a best practice. So another question from Miriam. We are a townhouse condominium complex looking to conduct a risk assessment. Has anyone in the chat conducted one and has a company name they could recommend? Okay, so I'll leave that for the chat to answer. If anyone can point out a security consultant that they have used successfully in the past. I don't have names that pop out at me as being particularly recommended, but I suspect if you typed in something like, condominium building security audit Toronto into Google, you'd probably get a few hits. And I would just start calling those people up and see what they charge and what they do. I think I've done it in the past, so sort of I can picture what their websites look like in their mind, but I don't remember the names. Okay. So some of the other things that are going on. So we talked about the announcement from the ministry, very exciting, that they might be changing deadlines and extending things. Obviously, totally important information for condominium managers to know, because this is how you plan your business, right? You need to know when your deadlines are, so you can prioritize different things. And if deadlines get pushed back, you want to know so that you can move your priorities around. So what's another deadline coming up? October 1st. What happens on October 1st? Condominium Authority Tribunal jurisdiction expands. For the first time since it was created in November 1st, 2017, we're going to get expanded jurisdiction for CAT. And I'm just going to check my notes so I say it correctly. But the issues that will be included are disputes relating to pets, vehicles, and parking, including not just cars, but bicycles, mobility scooters, and other types of vehicles, boats. Storage lockers and any item that is kept in a parking space or a locker area that maybe ought not to be. And then any claims for indemnification or compensation relating to the foregoing. So the real big one out of all of these, parking, vehicles, and lockers are important issues, but pets is the big one. And especially interesting is not just the fact that a condominium corporation can enforce its pet provisions at CAT, and that an owner can dispute those provisions at CAT, but also that an owner can bring a application, it would seem from the announcement, against a neighboring owner's pet, or the neighboring owner with respect to the owner's pet. And that is in my mind, that is a recipe for some really, really fascinating law. And you're going to have, absolutely this is going to happen. You're going to have people realize that they can do this. And, Unit 101 is going to be bringing an application against the barking dog in 102. And this is going to open up a world of neighbor disputes within condos that did not previously exist. Previously, there was no real mechanism for a neighbor to bring direct enforcement proceedings against another resident of the building. And in my mind, that just it opens up the potential scope of condominium disputes tenfold, because it just brings so many more potential relationships and parties into the mix that were not there before. Those relationships existed, but there was no litigation directly between them, or if it happened, it was extremely rare. So what we know from CAT is that when you make it easy for people to raise disputes over things like records, they do it. And what you end up with is a lot more requests for records now than you used to have, because of the existence of CAT, and the consequences of an application means that now owners are incentivized to request records, because if they don't get the records, they're entitled to fines and penalties and money. And the same could be true for incentivizing owners to bring applications against their neighbors for breaching condo rules. So it's questionable whether this is a good thing or not. I guess if you're a person living in a condo who hears barking dogs around you, it's a great thing. And if you're a person living in a condo with a dog, it's probably not a great thing. So that would be my prediction as to how that's going to go. But we'll see, October 1st, it'll be really interesting. And just as a gentle reminder, our firm has articling students, junior lawyers, and paralegals who specialize in this kind of stuff. So we expect to get really busy with CAT applications, and especially those relating to pets. Other things that are coming up. If you're in the city of Toronto, you might know that there is a short-term rental municipal bylaw that's been in effect for some time now. It was upheld in court, and then there was an appeal, and then that appeal also upheld the bylaw, and then that was appealed, and that appeal also upheld the bylaw. So it is like 100% in force, the restriction on short-term rentals in the City of Toronto municipal zoning bylaw. But there had not been a lot of progress towards implementing it. And one of the things was registration for short-term rental operators. Registration for short-term rental operators opens September 10th. So if you go to the City of Toronto website for short-term rental bylaw, you'll see as of tomorrow that people will be able to register. And for condominium managers, if there are short-term rentals being taking place in your building, then you will have an additional remedy if they're not registered, calling 311 as a way to achieve enforcement above and beyond the normal methods of enforcement, like writing compliance letters using the property manager and the condominium corporation's lawyer. So it's just more enforcement, more tools for condominiums to manage their buildings, which is great. So that's tomorrow for short-term rental. And then limitation periods. So a limitation period is the time within which you must commence a lawsuit, failing which you lose your right. And they were paused, retroactive to March 16th, and then they resume again September 14th. So nearly 6 months, less 2 days. Limitation periods were paused, so that 2-year time period is really going to be 2 years and almost 6 months for people who are caught into who have claims now, right? So that clock starts ticking again September 14th. Something very important to know if you had postponed commencing legal proceedings because you were of the view that the clock had stopped ticking. It starts ticking again September 14th. So the time is now to assess your claim and get your claim issued. You're allowed to issue your claim now while the clock has stopped ticking. So don't wait, do it now, because you don't want to get caught out by the limitation clock starting to run and you not realizing it. It'd be a big problem, especially if you're a lawyer. You have to call your insurer. Okay, more questions. We talked about announcements from ministry. I've introduced myself. Mental limitation. Great. Okay, so more questions. Property manager asks a question. Are there repercussions for the manager if an owner did not receive the notice of meeting package electronically in the prescribed time frame due to computer system error or oversight? Are there repercussions for the manager? I wouldn't say so. You have to look at the circumstances. So the temporary amendment to the Condominium Act, which we are now in, provides for loosening of the rules pertaining to notice. But I want to look up exactly what the wording is, and then I'll give it to you, because that wording is obviously extremely relevant to the answer to your question. So let me just pull it up here. It'll just take a quick second. Going to Condominium Act, way down to the bottom, schedule, service by electronic means, and it says, despite any provisions of this act or the regulations, or despite anything in the declaration or the bylaws, anything required by this act to be given to an owner or mortgagee in respect of any meeting is sufficiently served if it is given by electronic means. And then it says, for greater certainty, this applies even if the owner has not entered into an agreement to receive notices electronically. So, to my mind, and then it says, if the document shall be given in a form with any modifications necessary to reflect the change. Electronic means includes fax, email, or other computer network. Okay, so answering your question, the time limit within which to receive a notice remains the same. But I guess I would say if it was as a result of a computer error, like your email didn't go out the way it was supposed to, or maybe you typed the email address in wrong. That could be a type of computer error in a sense. I mean, it's a user error. And you thought you served it and then they didn't get it and you gave it to them a few days late. I would say that if the owner in question actually receives the notice, but let's say instead of getting it 15 days before, they got it 10 days before the meeting, and they attend the meeting, then that owner has, in my mind, waived any objection to the notice of meeting. And if they do object to the notice being late, they would have to tell you, and then it would be up to the chairperson of the meeting to decide if the meeting can go ahead, even though there was some defect in the notice. I think typically a chairperson would allow the meeting to go ahead as long as the owner had reasonable actual notice of the meeting. I mean, if a large number of owners didn't receive the notice at all and were unaware of the meeting, that would be different. You would have to redo it. So the only repercussion could be if there was sort of a widespread failure to give notice of the meeting and you had to reschedule the meeting. I mean, that's all that can really happen. And that is a decision that should be made by the chairperson of the meeting or the board if the board wants to cancel the meeting in advance because a large number of people didn't get the notice or got it really late. But, you know, if one owner got it a day late, I wouldn't cancel a meeting over that. I would call it an irregularity and I would proceed. And that's it. I mean, maybe I'm wrong for thinking that way, but that's what I would do. So, Miriam, some strong-headed homeowners want to hold the AGM outside instead of virtual and chair it themselves, hence our frustration and our constant explaining. Your early advice is useful. So this goes back to the question about virtual meetings and chairing and lawyers. And Miriam is saying that she's getting some pushback from owners who think that they should just do the AGM outside instead of electronically and chair it all themselves. And, you know, I'm sympathetic to those sentiments, but of course, that's not the best meeting, right? You're going to have a much better meeting if you do it professionally. And if it's about saving money, it's not a lot of money to hold a meeting, and it's well worth it. And if it's just about keeping control of things within the owners and not allowing in outside professionals, then we can all understand that that's not a good reason to have your meeting outside. Also, like, your plan to have your meeting outside is great until it starts like pouring rain, and then it's not that fun anymore. So, something to think about. Okay, next question. Can a condominium be held responsible if the city finds units operating short-term rentals when their enforcement starts? No, I wouldn't think so. I've never seen anything to indicate that that would be true. So the question is does the condo have liability if the unit owners are operating illegal short-term rentals? I couldn't imagine that you would. The condominium corporation is not the operator. They don't own the unit. You would be no more liable than if there was someone in one of the units doing anything that was not legal, like running an illegal liquor store or something like that. Now, if you knew about it and you didn't take any action, you sort of turned a blind eye, as a condominium, you would be held liable not to the city but to the other owners who have an expectation and a right that the condo will enforce the law and will take steps to curb any illegal activities in the building. So your liability is really to the other owners, but not to the city itself. That's my perspective on that particular issue. And now a different situation would be anything going on in the common elements. And that, by way of helpful segue, takes me to one of the other sort of hot topics right now, which is municipal mask bylaws for condominium common elements. Check off my list. So most of the GTA, City of Toronto, Mississauga, York region for sure, are all have in place very similar municipal bylaws requiring face masks or other face coverings, non-medical, to be worn in the common areas of residential condominium buildings. It was already previously required for commercial condominiums, but now also for residential. And as a condominium, if you are not enforcing that bylaw and you're not doing the things required of you by that bylaw, like training your staff, having a policy in place, and posting notices at all entrances, then you would be liable to the city for that. But that's different because it's not what's going on in the units, it's what's going on in the common areas that the condominium corporation is responsible for. And what I'm starting to see now is pushback, not usually from residents, but from visitors. So people come in to the condo as visitors, family members of residents, and they are not wearing masks, maybe because they have irrational beliefs against wearing of masks, or maybe because they simply just forgot and are feeling defensive. And then when they are being told to wear a mask or put one on by residents of the building, who they might be in an elevator with or anything like that, they're getting like upset and screaming at people. So what do you do about the situation of people not wearing masks in the building? People have asked, like, do you stop them from entering? Do you confront them? I do not support any kind of physical intervention when someone is not wearing a mask. I mean, you should, if you're able to, especially if you're a property manager or security staff, you should be able to say to the person, hey, you need to put a mask on. A demand like that is fine, but you don't want to like start pushing people out the door. One, it's not a good approach to enforcement, and two, it's counterproductive to the concept of physical distance, especially that the person is not wearing a mask and is probably against wearing masks and therefore sort of a high-risk person. So, so you're not physically stopping people, but you're enforcing after the fact by way of compliance letters or trespass notices, that kind of thing. So all of that is how you would enforce the mask bylaw. And then also we write mask policies for our condominium clients that further allow enforcement of these bylaws as if the mask bylaw from the city is like incorporated into the condominium corporation's existing rules. And so that allows for legal letters and sometimes charging back the cost of those letters under appropriate circumstances. So these are all things that we like to do to help our condominium clients keep their building safe. So that's all of the things that I wanted to talk about. I'm happy to answer any more questions that you may have. And just to sort of quickly sum up what's going on, we talked about the announcement from the ministry, the fact that the condo crunch for AGM deadlines is not going to be extended, but that the ability to hold virtual meetings after November 21st might get extended. And I read that might as it probably will, but we don't know when that will come in or for how long. Whether it's going to be a 30-day extension or 120 days, we have no idea. And then October 1st, you're going to see pets in the Condominium Authority Tribunal. So I'm sure there's a cat pun in there somewhere. And then short-term rentals on September 10th. You can register your short-term rental as an operator for the City of Toronto. Limitation periods start running September 14th. Municipal mask bylaws for condo common elements. These are all the things I wanted to talk about, and ways of holding an AGM. So if there's no more questions, then we'll call it a session for this week. I've been going for about 35 minutes. That's pretty good. And once again, I thank you for all your questions. I thank everyone for joining us. We really do appreciate it. We enjoy this time with you, and we love hearing from you. And you can email us questions too, and we will answer them on the next live stream, or we'll just email you back if it's specific to your particular condo. And I think that's it for today, everyone. So thank you so much, and Brian, we'll see you next Wednesday.